If we could just come to order, I've been asked to say that there's a message that I have here for someone named Brendan O'Callahan. So if Brendan O'Callahan is here, thank you. Our next speaker is John Murray, and John was a classmate of mine, so this will probably, well, this will date me. He was called to the bar in 1971. He's a former partner of mine and also a good friend of mine. He's chairman of the law firm of Genet Murray. I don't quite know what chairman means, but it sounds good anyway. John is involved in civil litigation with an emphasis on labor and employment matters, acting on the management side. He frequently appears in the Divisional Court and, for that matter, many other appellate courts. Most recently, he acted for 3 former vice chairs of the Ontario Labour Relations Board, and before the Divisional Court, he obtained a declaration that the terminations were invalid. So he's had some involvement in the in cases that end up in the press lately. He's going to tell us about how to write factums, and with that, I ask John to tell us all about that.
Thank you, Doug. The room has pretty well cleared out at the break, I see, which is a reflection on the stunning topic I'm asked to speak on. The factum, a case in a nutshell, that's really, in one sense, all that needs to be said. But I have half an hour, so I'll say more. Factum is an outline of the essential structure of a case without argument. It is a document which will, in the case of a good judge, be given about 15 minutes prior to a hearing. Everyone who writes about facta will stress brevity, clarity, and simplicity. If you read what judges urge on the profession, they always return to those simple thoughts. And they, in fact, repeat and repeat to the profession that it should be clear, simple, and concise. Avoiding, or not avoiding, one of their own rules, which is don't be repetitious. They continually repeat that, and there must be a reason, and that's because no one is, or few people are, clear, simple, and brief. First part of factum writing I'd like to talk about, or factum preparation, is in fact the writing component. I'm not going to read the paper which deals with the preparation of factums, but I am going to speak a little bit on writing, which doesn't get too much time in this paper. And I'm going to urge for your review in your own time a little article called Plain English for Lawyers, which is reprinted in the California Law Review. I think it's in the bibliography which is attached to my associate's paper, which if she were here she would want to take full credit for, and deservedly so, because I did not, in the preparation of the paper, follow the rule which I will urge on you, and that's write your own stuff. This little book, though, reminds us of some of the rules that will help in the drafting of facta. And let me read a little bit to you, not because I like long quotations, and not because this is a good idea in any kind of adversarial contest to have long quotations, but this is succinctly put. We lawyers cannot write plain English. We use 8 words to say what could be said in 2. We use old arcane phrases to express commonplace ideas. Seeking to be precise, we become redundant. Seeking to be cautious, we become verbose. our sentences twist on, phrase within clause, glazing the eyes and numbing the minds of our readers. The result is a writing style that has, according to one critic, 4 outstanding characteristics: wordy, unclear, pompous, and dull. Criticism of legal writing is nothing new. In 1596, an English chancellor decided to make an example of a particularly prolix document filed in his court. The chancellor first ordered a hole cut through the center of the document, all 120 pages of it. Then he ordered that the person who wrote it should have his head stuffed through the hole, and the unfortunate fellow was led around to be exhibited to all those attending court at Westminster. When the common law was transplanted to America, the writing style of the Old English lawyers came with it. In 1817, Thomas Jefferson lamented that in drafting statutes, his fellow lawyers were accustomed to making every other word a said or aforesaid, and saying everything over 2 or 3 times, so that nobody but we of the craft can untwist the diction and find out what it means. There is also in that introduction an example of good writing of a fact situation. And it is truly marvelous, and I commend it to you, and I'll read some of it because it is marvelous. It's from a judgment of Benjamin Cardozo in Palsgraf and Long Island Railroad. And just listen to how much is said in such a little space. Plaintiff was standing on a platform of defendant's railroad after buying a ticket to go to Rockaway Beach. A train stopped at the station, bound for another place. 2 men ran forward to catch it. One of the men reached the platform of the car without mishap, though the train was already moving. The other man, carrying a package, jumped aboard the car, but seemed unsteady, as if about to fall. A guard on the car, who had held the door open, reached forward to help him in, and another guard on the platform pushed him from behind. In this act, the package was dislodged and fell upon the rails. It was a package of small size, about 15 inches long, and was covered by a newspaper. In fact, it contained fireworks, but there was nothing in its appearance to give notice of its contents. The fireworks, when they fell, exploded. The shock of the explosion threw down some scales at the other end of the platform, many feet away. The scales struck the plaintiff, causing injuries for which she sues. It is truly a marvelous introduction to the case. What more needs be said? How succinct. There is not anything but economy. He doesn't say, despite the fact that the train was already moving. He says, though the train was already moving. His choice of words is excellent. There are no lawyerly phrases, no misty abstractions, no hereinbefores, no saids. In this little pamphlet, there are some wonderful rules of writing which ought to be observed. Use concrete words, not abstractions. And in order to have the broadest possible audience, this author chooses a verse from the Old Testament as an example of good language and compares it to an altered version which would be found in a modern environmental impact report. Old. As the Lord commanded, he lifted up the rod and smote the waters of the river, and all the waters that were in the river were turned to blood, and the fish that were in the river died, and the river stank, and the Egyptians could not drink the waters of the river, and there was blood throughout all the land of Egypt. New, freshly minted lawyer, environmentalist version. In accordance with the directive therefore received from higher authority, he caused the implement to come into contact with the water, whereupon a polluting effect was perceived. The consequent toxification reduced the conditions necessary for the sustenance of the indigenous population of aquatic vertebrates below the level of continued viability. Olfactory discomfort standards were substantially exceeded, and potability declined. social, economic, and political disorientation were experienced to an unprecedented degree. We lawyers don't make things better. His second rule, use familiar words, and for this, his authority is none other than Aristotle, whose name, please confess, you didn't expect in this lecture about factums in a nutshell. Style, said Aristotle, to be good must be clear, as is proved by the fact that speech which fails to convey a plain meaning will fail to do just what speech has to do. Clearness is secured by using the words that are current and ordinary. And that takes you to the next rule, which is do not use lawyerisms. Lawyerisms are words like aforementioned, whereas, res gestae, and hereinafter. They give writing a legal smell, but they carry little or no legal substance. They baffle and annoy. When used in legal writing, they give a false sense of precision and sometimes obscure a dangerous gap in analysis. Consider, for example, the word said in its archaic use as an adjective. No lawyer in conversation says, "The green beans are excellent. Please pass said green beans." Yet, legal pleadings and facta come out like this. Why is it? Aforementioned is said's big brother and is just as useless. The 50-acre plot aforementioned shall be divided. If only one 50-acre plot has been mentioned before, then aforementioned is unnecessary. If more than one 50-acre plot has been mentioned before, then it's imprecise. Either case, it's totally useless. Try to think about your prose. Try to think about using ordinary words, and it is the great deficiency. We have a lot of wonderful young men and women out of law school whose brains are much superior to those of us who graduated in 1971. There's blood going through them. It's all the right chemistry. But they can't write. And of course, that's a generalization. Of course, there are some exceptions, but, they're few and far between. Well, in fact, the court would say there are few persons who can write well no matter when they graduated. And if you read what the judges say about facta, you come to the conclusion that most aren't very good. The fourth rule, apart from the three I've mentioned on language, is write for the intended audience. First, the court. Second, your opponent. In writing for the court, keep in mind the purpose of the factum. There's a wonderful little article purportedly written by Ian Scott. I have a feeling reading the article that it may be like my article, except it would be unlike him not to give attribution, so maybe he in fact wrote it himself. It's part of the materials, or at least referred to, and it's well worth a read. And he indicates that while an argument is to be previewed, and therefore one should keep in mind conciseness, brevity, clarity, there are multiple purposes for a factum which in fact make that admonition a difficult one to follow. A preview of an argument. This is the first purpose. It gives the judge the opportunity to be prepared and will help the judge think about the case in ways you want him to or her to. There's an example of useless language, him or her. Helps the judge decide on a preliminary basis what questions may be relevant, what questions they may have with respect to the case that is before them. Secondly, the purpose is to provide an architectural drawing, to use Scott's language, of this case and of the specifics. Now, the architectural drawing itself in order to do a good job, will create tension with this notion of brevity and conciseness, precision. So one obviously is engaged in a balancing act, and to the extent that the case is a complex one, you may find that the need to do the architectural drawing does impinge modestly on your first objective, which is to have a simple and straightforward outline of the case, a preview of the argument. The third purpose is to provide to the court a technical resource for the judge in delivering reasons, either orally or for drafting if the decision is reserved. And all of us have had the horrible sinking feeling of reading a judgment and seeing the opposition factum in it in a big way. And sometimes we may have had the joy of seeing our own. But no one who appears before the courts, either in an appellate role or in a judicial review application, will be unfamiliar with the assertion that facta can influence outcome dramatically, either in terms of the questions, in terms of the court's understanding of the case, and in terms of how the outcome is related. The factum and oral argument. Oh, just before I get on to that, when Mr. Justice Reed was on the Div Court, he was a very precise individual, as you may remember. And just to give you an idea of how exhilarated he could become when faced with a good factum, he wrote the following: I wish I could set out examples here of the beautifully concise factums that have thrilled me as much as any well-tuned sonnet, some of which are masterpieces, but I cannot. Now, I think that means that there were examples, but he couldn't recall them, or he couldn't set them out, not that there were no examples. And he then invited people to go and see the registrar at the time, Mr. Bridges, to search through piles of facta to see if there were some of these masterpieces. But this a kind of a response, this Byronic response to a good factum may, in an exaggerated way, give you some idea of the response of judges to a very well-crafted document. I know that the better lawyers in our office, the better counsel, spend an inordinate amount of time on their facta, drafting and redrafting. It can, to a managing partner, turn up as bad time when it comes to rendering an account. But it seems to be, with very good trial lawyers and appeal lawyers, an unquestioned commitment which is essential to a case. And I believe that all of the best advocates have made this kind of an investment in facta, or memoranda of fact and law, as they used to be called. So it is probably worth putting your docket aside and not worrying about that so much, unless you're going to get solicitor and client costs, and then you can remember it, which is what Scott always used to do. He never docketed anything, but was unable to prevail overall because dockets now seem to be justifications for fees, which is it's another tragedy that it's probably a worse tragedy than bad writing. But we'll deal with that on another occasion. The factum and oral argument. The factum is an integral part of oral argument, but there are some rules here too. Do not read it to the court. It will make the judges mad at you. Refer to it from time to time and integrate it into a cohesive oral argument. Sometimes cohesive oral argument is challenging enough, particularly when interruptions from judges are not uncommon. In these cases, I think counsel may find that the factum is a convenient way to gather not only counsel but judges together and focus back on the case, on the roadmap, when you may have gone down a tangential road as a result of a question. Of real importance is to understand how facta are used by the court and have some view of their perceptions of what a factum does. And I am, at the risk of boring you, going to refer to a paper by Mr. Justice Blair, who has highlighted in a concise way the use of factums by the court. Factums, facta. No one seems to be consistent. We know what's right. He starts off his paper by observing that one of his fellow justices said after appointment and after being on the court for some time the following: "If I'd known when practicing law how important factums were to members of this court, I would have taken more care in preparing them." And then Mr. Justice Blair, having set that theme, sets out the four uses that he believes judges typically make of factums. One, preparation for the hearing. We've already touched on that. But what he says is that all members of the panel read the written material in advance. I would hate to use that as evidence that Mr. Justice Blair does not always tell the truth, but in fact, I think it may be an overstatement. Then he says, we usually follow this procedure. This is a more accurate reflection, I think. We first read the appellant's factum, followed by the respondent's factum, and then the judgment appealed from, etc. The factum is the first that the judge will have heard of your case. It gives you a great opportunity because you will have the undivided attention of the judge who reads it. The factum should be prepared with the view of explaining your case on a one-to-one basis. If your factum is properly prepared, you will create a favorable impression not only of your case, but also of yourself. Conversely, the judge's impression of both your case and yourself will be unfavorable if the factum is confused, verbose, and sloppy. So that is the first purpose. The second purpose is for use at the hearing. The factum and the oral argument should be integrated and developed together. At the hearing, the factum should maximize and support the oral argument. The oral argument need not slavishly follow the factum. It is unwise to read from the factum except for carefully selected passages. The value of the factum at the hearing is that it can relieve the judges of the obligation to take notes if in the course of argument references are made to the specific paragraphs in the factum stating the salient facts and argument. A good factum stimulates questions from the court and leads to a fuller discussion of the issues on the appeal or the judicial review. Counsel at the hearing is badly served by a poorly prepared factum. 3, delivery of oral arguments. A good factum is of invaluable assistance in the delivery of an oral argument. A factum is of the greatest use at this stage if it has impressed the court during preparation and has stood up well at the hearing. It assists in the statement of facts, in the formulation of the issues, and in the analysis of the law and authorities relied upon by the court. Fourth, reserved judgments. A factum should always be written with a view to its use in preparation of a reserved judgment. It constitutes the permanent and final statement of your case. If well done, it is of invaluable assistance to a judge preparing a judgment weeks or months after the hearing. It should do more than merely refresh the judge's memory of the argument. It should assist in legal analysis and in the resolution of conflicting legal arguments. Above all, the judge should have such confidence in it that it will be referred to as a considered statement of your position on all vital issues. Since much of the judge's work on reserve judgment is done at home, it's important at this step, as in the preparation of an appeal, to have the factum supported by well-prepared appeal books and case books. So from the bench, the perception of the importance of facta on those 4 occasions. There's one other point that I'd like to mention here, and it's referred to in the paper. In the Div Court, it is often but not always the case that a law clerk will prepare a bench memo to the panel summarizing the issues in dispute. So here again, the factum will be of critical importance. If the factum is good, it will assist in a higher quality memorandum to the judges that relates to the case before the court. So that may be number 5 in the use that the court finds for good facta. The purpose of the factum informs the content of the factum. The purpose is to identify what went wrong and answer the question, is it serious enough to warrant intervention? That really, when you cut it and dry it, is the purpose. What happened? Why did it go wrong, and why should we interfere? Obviously, the rules also govern the factum, and they govern the form of the factum, and I have dealt with the rules in the paper and won't spend a lot of time reviewing those with you. Part 1 of a factum must set out the parties bringing the matter to the court tribunal under review, the decision, the date, essentially what happened, succinctly. With respect to Part 2, the facts, this is an important area to focus on. Clarity, accuracy, and organization with respect to the facts is critical. Always consider why you are not using a chronological recitation of the facts. If there is a good reason, complexity of subject matter, etc., make sure that it's organized well. A cast of characters in an appropriate case is also critical. The fact of the matter is that with facts, the court will expect a kind of scrupulous integrity when it comes to writing down the facts. And there will be, if you're in court enough, so I'm told, a kind of erosion generally of your integrity if you are loose with facts in the factum. It is the case that judges will want to be able to read your picture of the case on the facts and assume they are presented with great integrity. Do not be repetitious. This is another problem that has been observed by the court, and there is in the bibliography, I think, a reference to an article called Common Problems in Fact Writing by Mr. Justice Brooke, and one of the things he complains about is repetition of facts as well as lack of integrity in the presentation of those facts. Part 3, issues in the law. Mr. Justice Brooke, in his article, repeats a caution to us as lawyers, which we probably don't always need just because we read facta from our own law firms and from other lawyers. But he urges to be selective with respect to the issues which are raised and not to use several different iterations of the same point or of weak points which detract from the real issues. So be selective. With respect to the law component of Part 3, relate the law to the facts. Don't use too many authorities, if a few will do. And Mr. Justice Brooke also spends time telling us how difficult we make life for judges if we are imprecise with respect to formulating the issues and if we use too many authorities. If there is a leading case, rely on it. You don't need 5 where there is the Supreme Court of Canada authority on a point, if it is the same point. If it's not, that's a different question. So, not too many authorities if it can be avoided. It doesn't help to list propositions of law as bald statements either. And it's of no help to set out that a board of arbitration is reviewable because of a patently unreasonable error. I mean, if there is a judge in the Div Court who doesn't know that, and I'm sure there is, you can tell that person orally, and there will be 2 out of 3 who will have heard it before. The preparation of the factum is critical as well. The lawyer arguing the case is responsible for the factum. Good advocates who make the argument will take ownership over the preparation and the end product. I commend to you Scott's article. He says this: learn the case, read the law, think of analogies, think of public policy, think of the administration of justice and how you can tie your arguments in, and he was a master at that. Read a chapter in a case book, in a textbook, maybe read a periodical article. I can't believe he ever did any of that. But in the end, prepare well, then write. Then write. Stephen Leacock said, writing is easy. You just jot down ideas as they occur to you. The jotting is simplicity itself. It's the occurring which is difficult. Follow the rules. Keep to 10 to 12 pages. Do a number of drafts. Each time it should get better, more concise and clearer. Go with winning points. And let me conclude, as I'm being urged to by my colleague, Mr. Gray, by reading the concluding paragraph of Ian Scott's nice little article under the heading Persuasion. It's often overlooked that the purpose of the factum, just like the oral argument, is to persuade. Its purpose is not to provide a treatise or to test the patience of your readers or to find the limits of their vocabulary or to make them read every sentence twice in an effort to understand it or to illustrate your learning. Its single purpose is to persuade the reader to a point of view and to do so with accuracy and fairness. Whatever purpose of the factum dominates in your particular case, it is not wise or necessary to set out in the factum everything that you will want to set out in your argument. It is foolish to try. And last, remember what the playwright David Belasco said: if you can't write your idea on the back of my calling card, you don't have a clear idea. Thank you.
Thank you, John. I just want to say a couple of things before we get on to the mock application for judicial review. First of all, obviously, a lot of what John said will be very useful in assessing the three factums that you will find in the material at tabs 7, 8, and 9. So as we proceed through the mock application itself, you might want to bear in mind a lot of what John has said in seeing how those are used during the process. Secondly, I just want to explain how we're going to do this mock application. We're going to set it up so that the three persons who constitute the panel of the court that will hear the matter will be sitting in the front row, and we will have counsel address the court from here, so that counsel will actually be facing the audience in doing their presentation. So what we're going to do is just take a few minutes to get that set up, get the panel in place, and counsel will be sitting up at the front. So I'd ask you not to go anywhere, because this will only take a few minutes. And then once that's been done, then I will introduce the participants, at least those that haven't already been introduced, and then we'll get it underway. After it's finished, we intend to have, I'm assured by the panel that they do intend to actually deliver a judgment. So this will give the counsel some incentive to do their usual outstanding job, and hopefully we'll have time for some discussion and perhaps some questions. So thank you for your patience. We'll just be a few minutes. All right, I think we're ready. What I'd like to do is to introduce the participants in the mock application, at least those who haven't yet been introduced. Counsel for the applicant in this application is Chris Riggs. In addition to being one of my partners, I can say with all the modesty that we can muster that he is undoubtedly one of Canada's finest administrative and appellate lawyers. Recently, he acted in two matters in the Supreme Court of Canada. One you will have read about in the press, involving the Brant County School Board and Eaton, in which the rights of the disabled to participate in a regular classroom setting was addressed by the court. And Chris just found out 2 minutes ago that he won another case in the Supreme Court of Canada. So that I'm sure he's in a good mood. Chris Paliare, who will be acting for the trade union respondent in the application, was called to the bar in 1973. He's a partner at Gowling, Strathy, and Henderson. He's engaged in civil litigation, primarily in labor relations and employment law on the trade union side. He's frequently in the Divisional Court. Recently, he acted for the Canada Labor Relations Board in the Supreme Court of Canada in the Royal Oak Mines case. Now, I note that Paliare referred to that decision in his factum as one of the authorities. I don't think he referred to any of his losers in his factum. But I don't recall any. But at any rate, the third counsel is Howard Goldblatt. He was called to the bar in 1976. He's a partner in the firm of Sack Goldblatt. Who's the other Goldblatt? Well, anyway, he's also involved in primarily trade union labor relations matters. He's also frequently in the Divisional Court. I can tell you that recently he acted for the Pay Equity Hearings Tribunal in a case in the Court of Appeal involving Glengarry Memorial Hospital. I had the pleasure of losing that case, so I can tell you quite well how Howard acts in these matters, and his acts is very good. Lastly, I'd like to introduce the chair of the president of the panel of the court who will hear the case, Justice George Adams. And Justice Adams, of course, has had an outstanding career, and it's hard to know where to start in describing it. He has at one time or another in his career been an academic, a senior public servant, a mediator, an arbitrator, chair of the Ontario Labor Relations Board. He's acted as counsel, and since 1991 he's been a judge of the Ontario Court General Division. And of course, he's got a long way to go yet. I can say that it would be very difficult to find somebody who is more qualified to engage us in some discussion of administrative law or appellate issues. Quite literally, he has lived administrative law from every perspective imaginable in this area. And we are very fortunate indeed to have him with us to share the morning with us in this way. So I'd ask you to welcome particularly George Adams for coming to share this with us. And with that, I'll turn it over to counsel to argue the case.
Are you going to use Chris, the mic? You're going to go over there?
I've got the papers there, it's just easier. Is that going to pick it up? Yeah. That'll... Your Honor, this is an application to this court to quash the decision of the Ontario Labour Relations Board dated January 31 of this year. The issue before you is an issue that relates to the jurisdiction of the board to award the particular remedy it did. Now, the court should have in front of it, as I'm sure it does, copies of the application record, copies of the factums by the applicant, the respondent, and the board, and case books filed on behalf of all parties. I assume that the court has that. I assume also that the court will be familiar with the facts in this case, and I can review them very briefly before getting into the submissions before you. You will have seen from the record that there was an arbitration award by a Professor Harry Whittaker. I gather that's how his name is pronounced. He dealt with a discharge grievance involving Mr. John Doe, who was discharged by the company for theft. There was eyewitness evidence before him to support the theft. Theft was denied by the grievor. The arbitrator accepted the evidence of the company. He believed there was no reason to mitigate the penalty, and the grievance was dismissed. by way of a decision dated the 16th of August of 1996. There was then an application under the duty of fair representation provisions to the Labor Relations Board. The applicant stated to the board at that time that he had stolen nothing, and that what had happened was that the union had completely failed to put in his case before the arbitrator. Before the board, both the union and the employer called no evidence, and the decision of the vice chair, Mr. Jones, was to the effect that the allegations of theft were unfounded, and the board then had to deal with the appropriate remedy. The position of the union and the applicant to the board was that there should be a second arbitration held to address the issue of cause. The employer took the position then, as it does before this court, that there was no jurisdiction in the board to order a second arbitration, and it relied then, as it does before this court, on the decisions by this court in the Mordawanek case and by the Supreme Court of Canada in the Gendron case. What the board did, however, was to decide that it would not order a second arbitration, being concerned, it would appear, that its jurisdiction to do so was limited by those cases, and it went on instead to order reinstatement of the employee. And I think it would be useful if I just read one paragraph, paragraph 17 of the board's award, which articulates the reasoning that the board followed, and it's found at the bottom of page 14 of the record. I quote, "In this case, the board does not need to order a second arbitration in order to remedy the violation of the Act that I have found has occurred. A second arbitration might be necessary in cases where there is some dispute on the facts or where the outcome of any possible arbitration is in doubt. In this case, however, that is not the case. The unchallenged testimony before me makes it abundantly clear, in my view, that there is no cause whatsoever for the applicant's dismissal. His evidence was unchallenged. I recognize that the evidence is unchallenged because of strategic decisions made by the intervener employer in the way that this litigation should be conducted, but nevertheless the evidence before me is unchallenged and I must accept it. Accordingly, the remedy that is awarded to correct the violation of the Act is that the grievor be forthwith reinstated to his employment with full compensation for any loss he has suffered as a result of the dismissal and as a result of the violation of the Act, together with interest." Now, my submission to the court can be put very simply, and it is this: that the Labor Relations Board did not have the jurisdiction to order a second arbitration, and by extension, could not have the jurisdiction to order a reinstatement. And in my submission, this issue is a simple one because it is a matter that is governed by authority, that particular issue having already been canvassed and adjudicated by this court in the Mordawanek case and by the Supreme Court of Canada in Gendron.
Mr. Riggs, both of those decisions are earlier in time than the Supreme Court's decision in Newbould, which uses a pragmatic and functional test to determine jurisdiction. And you know, Mr. Paliare really relies on the Newbould framework to support the conclusion that today Gendron and Mordawanek would be decided differently, that the Divisional Court, using a pragmatic functional test, ought to find that the construction of, I guess it's section 94 now, or whatever the enforcement power is a provision that the legislature intended the Labor Board to interpret and apply its expertise to. And thus we aren't confronted with the jurisdictional issue. It's a matter within the board's jurisdiction, and we ought to be then applying a patently unreasonable test. And he says, can't be patently unreasonable. You might quarrel with the conclusion, but it's not a patently unreasonable conclusion for the Labor Board to say in a DFR proceeding, we can reinstate and we can do things that overlay this earlier arbitration, but we're exercising our jurisdiction, not an appellate jurisdiction.
I think I can answer your Lordship's question in two ways. The first point would be that the approach which both the Supreme Court of Canada took and the Divisional Court took in Waterwanek was based on the Acadie decision in 1984, the thrust of which, to quote Mr. Justice Eberly, is that I consider, therefore, that it is not doubtful but manifest that the interpretation of those provisions raises a question of jurisdiction about which the Board cannot err without committing an excess of jurisdiction, in other words, a correctness test. Now, what I would submit to the Court is that the decisions that start from Bibeau and go through from there, in fact, would lead to the same conclusion. And the reasoning is this. The very most fundamental thrust of the Supreme Court of Canada in deciding the scope of review is to say, what is the intention of the legislature in formulating legislation of this kind? Who do they intend will make the decisions? Now, my submission to you is that when you look at that very basic approach, that the conclusions the Supreme Court of Canada reached in Gendron will apply with equal force today, and that is that there is a role to be played by the Labor Relations Board in dealing with duty of fair representation complaints, which will involve some jurisdiction, will involve some remedial authority, but that has to be seen consistent with the authority that is granted to arbitration boards under the Labor Relations Act to come up with a final and binding decision. My submission to you is that what Bibeau would say is you have to look at that legislation and see what separate responsibilities are given to those two tribunals. And that, as I'll deal with very briefly, is a distinction and a separation of jurisdiction that holds just as much in 1996 as it did when Bibeau was written and when the decisions in Waterwanek and Gendron were written, and in terms of the Acadie jurisdictional argument. Now, in the Waterwanek case, as the court will recall, you had a situation with a grievor who resigned from her employment. A grievance was filed alleging unjust dismissal, a decision by Professor Palmer in terms of the voluntary resignation, and then a decision by the trade union to go to the board, and the board, in fact, ordering a second arbitration. And where the majority of the Divisional Court, in fact, had to deal with exactly the same issue that confronts this panel today, and that is, does the Labor Relations Board have the authority to order a second arbitration? And one of the advantages of that decision is that the two competing views were canvassed by the court quite directly. You will have noticed that the decision of Mr. Justice Saunders stands for the proposition that it is appropriate to order a second arbitration because he characterizes what is being done there as really the trial of an issue, which is not inconsistent with what the Labor Board can have the authority to do. That viewpoint, however, was not accepted by the majority. And the thrust of the majority's decision is to say, once that decision has been made by an arbitration board, that decision under our statute is final and binding. And whatever remedial authority that the Labor Board may have, it has to be one which is exercised consistent with a recognition that that arbitration board decision is final and binding. You can't treat the Labor Relations Board as having an appellate authority in relation to an arbitration board decision. That is explicitly set out by Mr. Justice Eberly for the majority, and in my submission, our case is stronger because you could argue in Waterwanek that what the second arbitration board was being asked to do was to deal with a slightly different issue. In other words, to deal with the question of just cause as opposed to the issue of the voluntariness of the quit or discharge in the first place. In the case before us, there's no question that the issue before the second board would have been exactly the same as the issue before the first one. That proposition is underlined even more clearly by the Supreme Court of Canada in Gendron, because there you had an arbitration board dismissing the grievance, as is the case here, a breach of the statutory authority at arbitration, as we have here, a labor court ordering a second arbitration, as we have here, and the Supreme Court of Canada indicating that it had no authority to do so. It founded its decision on Section 101 of the Labor Code in the province of Quebec, which refers to arbitration as being without appeal and binding on the parties. In my submission, the distinctions in the language between that and the Labor Relations Act are of no significance in terms of determination. What is interesting as well is that subsequent to that, the decision in Extendicare appears to suggest an approval by the Court of Appeal of the reasoning in the Mordawanek case. We are then left, Your Honor, at the end of the day with the situation where authority is clear to the effect that there cannot be a second arbitration. Now, what the board has done here is to avoid the problem of the second arbitration by saying we will in fact go to the end of that potential process and order reinstatement. My submission to you is that if the court does not have the authority to order a second arbitration, if it doesn't have the authority to say to the parties, you have to go through the process of arbitration a second time, where there is the potentiality for either reinstatement or upholding the discharge. The board can't get round that restriction on its jurisdiction by saying, well, what we will do is we will go to the end of that process and say we reach a determination that there be reinstatement. And the reason they can't, with respect, is because you cannot have that decision sitting together with the decision of the arbitration board. To say that Mr. Doe will be reinstated is effectively to say that the arbitration board decision has been successfully appealed. That the Labor Relations Board does not have the authority to do. Now, the question may then be raised, well, what kind of authority does the Labor Board have? And the answer to that is partly dealt with by Mr. Justice Chouinard in Gendron. What he says is that is not an issue that we have to deal with. Now, that may be a hard approach to take, but with respect, it's a realistic one, because given the separate responsibilities of both tribunals, the question becomes not what those authorities are, but whether there's an authority either to award reinstatement or to have a second hearing. The practical answer to the question, however, is that the Labor Relations Board does have a wide authority, as long as it doesn't infringe on the authority of the Arbitration Board. And the obvious solution to that would be an authority in terms of compensation or some kind of other remedial order. But it cannot be one that interferes with the statutory jurisdiction of the Arbitration Board.
It could run a remedial order against your client?
There could be potentially a remedial order against the employer, yes?
And it could be monetary payment that compensates for the loss of a job?
It could be monetary payment against both the employer or the trade union. There may even be statements that the employer would be required to post. There may be some kind of...
But isn't that running in the face of the arbitration award? If any aspect of the compensation was to compensate that complainant for the loss of a job, we're looking at the Palmer Award, not the Palmer Award, but we're looking at
The Whittaker Award.
The Whittaker Award as justification for what your client did.
What I would say in answer to that is that the compensation could be compensation by the union, against the employer, but it could not be something which directly infringes on the award of the arbitrator. Compensation could provide that and still leave the legitimacy of the arbitration award.
But the arbitrator could have just made an award of compensation as well. I mean, the arbitrator could have done just that.
The arbitrator could have done, Your Honor, I don't take issue with that. The problem with any case where you are dealing with the edge of jurisdiction as between two competing bodies is each case is going to be fact-driven. And there may be situations where an arbitrator has made a particular kind of award where the Labor Relations Board would be able to intervene more directly in one case than in another. All I'm saying is that whatever that jurisdiction is, it's going to have to depend upon what the Arbitration Board factually did in each particular case. As the Labor Relations Board here said, no reinstatement, that has to be respected. There's no appellate jurisdiction in the Labor Board.
Mr. Riggs, if the matter had never gone to arbitration, so that the employee had never challenged in front of an arbitrator his dismissal, could he come to the Labor Relations Board and under Section 94, under the board's jurisdiction, get an order of reinstatement even though he'd never gone to arbitration to take issue with his dismissal because an arbitrator had not made a decision?
In my submission, Your Honor, yes, he could, and yes, the Labor Relations Board could make that order, because to make an order either of reinstatement or to go to arbitration in those particular circumstances would not infringe upon the decision, the binding decision made by an arbitration board. So under those circumstances, I would take a different position before the court. Thank you, Those are my submissions.
Thanks, Mr. Riggs. Mr. Paliare. Might as well stay there. Might as well go out. Okay. I'll just speak up.
Your Honors, there are two issues that I'd like to address to the court today. First is the matter of jurisdiction, and the second is the standard of review. Mr. Riggs has not touched on the standard of review that ought to apply in this case. I can tell you at the outset that there is some overlap with respect to those two principles that we want to put before the court. They are not watertight compartments. Let me begin with the first proposition, that is the jurisdiction of the Ontario Labour Relations Board to reinstate the grievor pursuant to the remedial authority of the board under Section 96(4) after making a finding that there was a breach of the duty of fair representation as it related to Mr. Doe. In order to understand and appreciate the respondent's argument with respect to both of the issues, but in particular the jurisdictional issue, in my view, you need a brief overview of the legislative scheme which has created the Ontario Labour Relations Board, and more particularly, to review the nature and role of the OLRB in the context of the duty of fair representation as set out in Section 94 of the Act. The purpose of the Act, as set out in Section 2 of the Labour Relations Act, broadly speaking, sets out a legislative framework that is designed to encourage and permit employees to select a trade union of their choice to act as their exclusive bargaining agent in the process of collective bargaining with an employer. And what you have are three principal actors in the relationship as the legislative scheme is set out. And those three actors are the employer, the trade union, and the individual employee affected by the collective bargaining process. The essence of the relationship between an employee who is part of a bargaining unit and the bargaining agent, that is the trade union, is rooted in the notion of exclusivity. That is, you've got one trade union that acts for all of the employees. The majority of the employees, once they select the trade union, decide who the trade union will be and whether the individual wants to be a part of the trade union or not. They're swept in by the notion of majority rule and the whole concept of exclusivity that passes to the trade union. That exclusive bargaining agent then has the right to engage in collective bargaining in order to affect the terms and conditions of employment of the entire group. Whether the individual agrees with those terms and conditions or not becomes irrelevant. Now, the trade union, having that exclusive authority, also has the exclusive authority to deal with the grievance and arbitration provisions of the collective agreement. Now, the courts were the first to recognize that there was a serious power imbalance between a trade union and any particular individual who may be represented by that trade union. And that power, of course, could be abused. And what you have in any bargaining unit, Your Honors, is a diversity of interests amongst the group. You may have, for example, young employees who want more wages as compared to a group of older employees who want less wages and more pensions. Or there may be a dissident member of the bargaining unit who disagrees with the way in which the president of the local union is running it, and there may be some tensions involved in that. So what the courts recognized was that you had to be able to permit this diversity of interests to be dealt with in this democratic institution in a fair and flexible way, but also to preserve the rights of individuals to ensure that the abuse of power wasn't such that the individual's right was totally eliminated. The courts didn't want to micromanage all of the decisions of the trade union. So the balance that was struck was the creation by the courts of the duty of fair representation. That is, that a trade union could not engage in conduct that arbitrarily, discriminatorily, or in bad faith affected the individual in the representation of that individual vis-a-vis the employer. Now, that court-created remedy, in order to balance these two rights, got adopted by the legislature in Ontario in 1969. Now, again, that's the first part of the legislative scheme that I think is important to understand before you can get to the issues in this case. The second thing to remember is that at the heart of the Ontario Labour Relations Act are a number of unfair labor practices. These are types of conduct that is prohibited because it would adversely affect the delicate labor relations scheme that's set out by the Act. And there are, between sections 70 and section 88, that is 18 sections, 18 different types of prohibited conduct, only one of which is the duty of fair representation. So that's the legislative scheme, and who is to administer it? A specialized expert tribunal, the Ontario Labour Relations Board. But you must remember that these unfair labor practices go right to the heart of the board's specialized expertise, because the courts have recognized over the years that they are the group that are best able to understand what the real issues are between the parties and the way in which the board ought to make the resolution is one that should have and does receive the greatest amount of deference. With that legislative background, let's move to this particular case. What did you have? What was the issue before the board? It was a narrow issue. Had there been a breach of the duty of fair representation under Section 74 of the Labour Relations Act? No allegations of any violation of natural justice. Everybody had the right to participate. They did. They called whatever evidence they wanted, and factual findings were made by the board, which were accepted at the uncontradicted evidence of John Doe, led to the conclusion that there had been a violation of Section 74. So from a pure jurisdictional point of view, the board had the authority to embark upon this inquiry. It did so in a proper fashion, heard the evidence, made the finding, and now you move to remedy.
Paliare,
Yes.
Just before you do that, if you look at the record, page 13, paragraph 8,
Page 13, paragraph 8 of the record at tab 6.
yeah, tab 6,
Yes?
and the third sentence, the court says, I'm just responding to your no natural justice, and of course, Mr. Riggs hasn't argued natural justice, but the statement, I recognize that the merits of the discharge as such are not directly an issue in these proceedings. And then the board goes on to dispense with, or to pronounce on the merits and reinstate. And I was kind of troubled by that sentence.
That sentence is anomalous, and one, in my respectful view, that is inconsistent with the entire decision. In my respectful view, the matters that related to the discharge had to be in issue in the sense that when one looks at the decision as a whole, Mr. Doe called witnesses and talked about not only the perfunctory treatment that he received from his trades union, but also got into the issues that related to his dismissal. And so what I say to Your Honor is that one must look not at any particular sentence. You have to remember that it's an expert tribunal, but these are not judges that are writing these awards, and that if you remember the admonition of Chief Justice Dubin in the CBC case, one shouldn't extract a shard or a piece of a decision and put it under a microscope. But when looked at as a whole, in my respectful view, what you have is a very complete picture as to what occurred at the hearing. And that then moves you right into the issue about what the remedy should be for the breach. There's no doubt that there was a breach. And when you look at the remedial role of the board, one must look at section 96.4. And if I could ask the court to look at that particular section, it's in my friend's factum at tab 8 at the very back under section 96. It would be about 4 pages in from the back of tab 8. And what my friend Mr. Riggs wants to do is he wants to rewrite that section, because clearly it's a broad remedial authority that the board has, and it's designed, subsection 4, is designed to deal with the remedies for all of the 18 potential violations of unfair labor practices between sections 70 and section 88. And what it does is at subsection 4 is that once there has been a violation, the board is mandated, it shall determine, you'll see that about 6 lines down, what, if anything, these various groups will do once there's been a finding. And of course, over at subsection C, one of the things it can do is to order reinstatement in employment. What Mr. Riggs says to you is, oh yes, but not if it's a section 74 complaint, that is a duty of fair representation complaint, in which there has been a finding of perfunctory conduct by the trades union in the presentation of an arbitration. So he wants to carve out of the plain, clear words of section 96.4 a remedial authority that, in my respectful view, the board clearly has.
He says Extendicare did that. Do you agree with that?
No, I think Extendicare was the complete flip side of that. What's Extendicare in the Court of Appeal, I think as Madam Justice Weiler said, was that you can have a, what she did is she distinguished it, if I can put it differently, the rights, private rights versus public rights. That is, you can have contractual rights under a collective agreement, and those can be dealt with, and you may end up with an inconsistent decision from a statutory tribunal like the Ontario Labour Relations Board, which has a public mandate to regulate this public statute. And so the decisions, although they may be inconsistent, deal with different rights. One deals with contractual private rights, the other deals with statutory public rights that, and interestingly enough, the rights of the parties are different, because the contractual rights under the collective agreement are the rights of the trade union, whereas the rights of the under the Ontario Labor Relations Act, under Section 74, is the right of the individual not to have his representation done in an unfair fashion.
Mr. Paliare, just on the wording of Section 96.4, you told us earlier that there's only one duty under these unfair labor practices in the Act on a trade union. And I'm wondering whether when the finding that the board made was a violation of a duty by the trade union, whether the board hasn't in effect granted a remedy against the employer under Section 96.4, and whether you should read the remedial jurisdiction as relating to that party that is in violation of the Act.
It's a very good question, Your Honor, and it's one that I'm happy to address. And what it does, in my respectful view, to put that proposition in its proper context, is to say that, again, the legislature would have wanted to carve out a remedy from 96.4. It didn't say, for example, it might have said, as the case may be, so that they would have intended it to apply to a particular section as the case may be. They don't say any of that. What they do is they give this broad remedial authority for all of the unfair labor practices. And to say that that it would be inappropriate to make a remedy against the employer where the unfair labor practice was against the union is, in my respectful view, one that you have to look at, A, the jurisdictional question: does the board have this authority? Is it limited in any way? And if it's not limited, to place a limitation on it is, in my respectful view, to rewrite the legislation, something the court shouldn't do. And what you then move to is the standard of review. Say, now, is this a decision which falls within the jurisdiction of the board, and is it one that is patently unreasonable? In my respectful view, it's not, and I urge you to dismiss the application for judicial review.
Thanks, Mr. Paliare. Mr. Goldblatt?
You know what, Thank you. I'm indebted, Your Honors, to my friend for assisting me with the microphone, and also assisting me in significantly shortening my presentation to your court today. The Labor Relations Board, of course, is not here to descend into the arena and to engage in a debate over the factual dispute as to the correctness of the decision. We are here only to provide you with our assistance on the key issue, and that is the extent of the board's jurisdiction to determine whether this decision is within the course of its appropriate decision-making power. From the board's perspective, it is our fundamental submission that the decision of this board is something which was within its exclusive jurisdiction to determine, and not only with respect to whether there was a breach of the duty of fair representation, with which no party takes issue, but also, more importantly and more fundamentally, with respect to the duty of the board to fashion an appropriate remedy as it is empowered to do under Section 96 of the Labor Relations Act. Now, I can do no better than perhaps to refer you to the decision of the Supreme Court of Canada in Mr. Paliare's case, the Royal Oak Mines case. In that case, the court quite clearly stated that the matter of remedies are something which fall directly within the specialized competence of labor boards. It is this aspect, perhaps more than any other function, which requires the board to call upon its expert knowledge and wide experience to fashion an appropriate remedy. And the section of the legislation under which the board is making its determination. The wording of the Act, which is only one of the factors that the Supreme Court of Canada in Bibo has suggested is part of the functional and pragmatic analysis. That section, which is set out at paragraph 11 of our factum, gives to the board quite clearly an extensive discretionary power to determine what remedy is best able to address the breach of the section. Again, I come back to this very fundamental point. There is a breach of the Labor Relations Act. There is a breach of the duty of fair representation, not disputed. And so the legislature has said it is now for the board to determine, and I quote, what, if anything, the employer, employer's organization, trade union, and so on, shall do or refrain from doing with respect to that breach. And the Act goes on to make it quite clear that without limiting the generality of the foregoing, and that is, it's a very broad remedial authority, without limiting the generality of that, amongst the specifically enumerated remedies which the legislature clearly provides for is the authority to order to reinstate in employment.
Mr. Goldblatt, what's troubling me is this. In Royal Oak Mines, and I'm looking at Mr. Paliare's factum, at tab 8, page 11 of the materials, tab 9 of his factum, paragraph 20. The court says, once it has been established by the provisions of the empowering legislation that the board does in fact have jurisdiction to order certain remedies, the question of which of these remedies the board chooses is within the board's jurisdiction. I don't think anybody quarrels with that. The difficulty I'm having is in understanding whether or not the power to reinstate when there is an arbitration award saying don't reinstate is or is not one of those powers that the board has. In other words, is this a jurisdiction conferring or prescribing provision, to use the Bibo analysis? Or do we know for certain, is it established that the board has this jurisdiction? It seems to me that, speaking for myself, that that's what I need to know to know what standard of review to apply.
Well, with respect, I don't think this decision can be looked at as against the arbitration decision. The Labor Relations Board is obviously not sitting in review of the Arbitration Board. The Labor Relations Board is getting its jurisdiction under the statute to determine whether there has been a breach of the statute. And as the Court of Appeal has said in Extendicare, that is a public right as perhaps opposed to the private right which is being litigated by an arbitration board. And you can't, I think the error that my friend Mr. Riggs is making is he's trying to compare the result of the arbitration decision with the result of the Labor Board decision, and they're not comparable because they deal with very fundamentally different things. So you come back to the statute, you come back to all of the tests which are set out in our factum, which I'm not going to repeat with respect to Bibo, and all of it points to the fact that the legislature clearly intended that there must be a way in which the Labor Board can effectively deal with what it's found to be a breach. And it's not restrained.
What do we do with this specter? And it occurred to me as I was looking at the fact situation, you get the union going to arbitration, and it loses. And the employee obviously doesn't like it. So it files a DFR. The union knows how difficult it is to be here challenging an arbitration award. So the union sits back and does nothing at the board. In effect, admits a violation of the duty. And then it gets a shot on the merits again before the board. And the board then reinstates, gives this employee exactly what the employee was denied by another tribunal that's of parallel jurisdiction. And it's open to abuse.
And it may well be open to abuse in appropriate circumstances. This is certainly not one of those circumstances.
Well, how do we know it is?
Well, because the facts of the matter, the record before you, quite clearly demonstrate what happened. It's not as though the employer came before the board and said, look, I want to call evidence with respect to this matter. The employer sat back and, for whatever reason, did not dispute the evidentiary history as it went in. And so the Labor Board at the end of the day is left with as uncontradicted evidence with respect to the fact that the theft did not occur as the Arbitration Board was left with respect to the fact that it did occur. And the evidence that's adduced by the applicant before the Labor Relations Board is quite clear to the effect that the reason that that evidence was not adduced before the arbitrator, and the board so finds, was because of a clear violation of the duty of fair representation by the union. They did not do their job. And there's no question of subterfuge. And Mr. Riggs doesn't come here and say, which I think is significant, well, there wasn't a breach of the duty of fair representation. No one's challenging that. If it had been another matter, if the employer had sought to seek review of the board's decision with respect to whether there was in fact a duty of fair representation, your concern might be raised. But it's not. The issue is, what is the appropriate remedy in a clear, unchallenged finding of a breach of the duty? And in those circumstances, clearly it's up to the board to fashion the appropriate remedy.
Mr. Goldblatt, I just, maybe you've already dealt with this, but let me ask you, could there be such an egregious conduct on behalf of a trade union?
Theoretically.
In representing an
Only
employee,
theoretically.
in representing an employee, that the Labor Board would have jurisdiction to declare the arbitration effectively a nullity?
Well, I mean, the difficulty you have is I don't think the Labor Board can sit in review of the arbitrator's decision. But in these circumstances, they're not sitting in review of the arbitrator's decision. They are fashioning their appropriate remedy in respect of their proceedings.
Well,
Now,
but they aren't, I don't think. I mean, my problem would be this. If they have jurisdiction that fits together, if you look at Section 114 of the Labor Relations Act, it talks about determining questions of fact and law that arise in any matter before it. In the case before the board, Labor Board, it was an unfair representation case. And then that decision is final and binding on the parties. But that's exactly the same language that the other section uses with respect to the arbitration award. How can there be two final and binding decisions which are completely inconsistent? How does that fit together?
Well, I think that that anomaly, as you may consider it to be, is exactly what was addressed by the Court of Appeal in Extendicare. I mean, the fact of the matter is that there can well be, as the Court of Appeal said, decisions which amount to there being a certain amount of overlap or even inconsistency when they in fact deal with fundamentally different issues and have fundamentally different facts before them. There's no question that this arbitration decision is final and binding in respect of the issues that were argued before it and in respect of the matters that were raised. But you can't ignore the fact, as the Labor Board has determined, that the reason that the decision of the Arbitration Board is as it was is because of the breach of the union's duty of fair representation. Now, that does not give us a ground for seeking judicial review, perhaps, of the arbitrator's decision, and as Justice Adams points out, it is extremely difficult to get judicial review of an arbitrator's decision. But on the other hand, you're left with what is clearly a breach of a duty, a fundamental duty, as Mr. Paliare has outlined, historically derived, to represent fairly and appropriately all employees within the bargaining unit. And in that case, the arbitration decision may well have to stand aside in a practical basis to the Labor Board's determination to order reinstatement. And that creates perhaps an inconsistency, but it's an inconsistency that's based upon the difference in the procedures, the difference in the evidence, and more importantly, it's an inconsistency that results from the Labor Relations Board exercising what is its fundamental jurisdiction to do, and its exclusive jurisdiction to do, and that is to fashion an appropriate remedy in
Well, I
these
don't want to
circumstances.
prolong this case, especially since I'll have very little to do with the actual decision being made by the court.
As it should be.
As it should be.
I think that's extremely appropriate.
But it seems to me that they have they have wandered into determining the very issue that was before the arbitration board, and I don't find this distinction an easy one to accept. I understand it theoretically, but in fact, I don't know why they just haven't gone in there and made the decision on the merits and substituted its opinion for the arbitration board.
Well, I mean, I'm not going to debate with you whether your view of the matter is correct or is not correct. I mean, the question is, if you find that, I would, perhaps with respect, to debate with you, but
We're
with
not
Mr.
here to debate.
With Mr. Murray, I don't know. The bottom line in all of this is that unless you find the decision of the board to be clearly irrational, which is the standard of review we would urge upon you because it's being within its exclusive jurisdiction, clearly irrational, whether you agree with it or don't agree with it as a practical matter with great respect isn't the point. As long as it's within the scope of the arbitration of the Labor Relations Board to determine, and we submit it is, within their jurisdiction to determine, providing that it is not clearly irrational, which we submit it isn't, this court ought not to interfere. And you may be concerned, you may be troubled, but again, I just respectfully remind you, this is not an appeal. This is a review, and in those circumstances, we would ask that the board not interfere, the court not interfere with the board's determination. Thank you.
Thanks, Mr. Goldblatt. Any reply?
Very briefly, Your Honor. The position taken by my friend, Mr. Paliare, which I think is adopted by Mr. Goldblatt, is that when you're looking at the question of fashioning a remedy, you have to look at the legislation, an approach with which I take no dissent. But when you look at the whole of the legislation, you then have to answer the question, well, are there some remedies that are available for one tribunal, the Labor Relations Board, and are there some available for the Arbitration Board? Because when you look at Section 44 as it then was, and Section 89 as it then was, what the legislature has done has set out different responsibilities, recognizing, as I believe my friends would agree, that the role of the Labor Relations Board is not to sit in an appellate capacity. It is not for the board to say, we do not like what has been done by the Arbitration Board. That is a responsibility for this court. And that distinction, recognizing that there is no sort of hierarchy between the Labor Relations Board and arbitration boards, was explicitly stated by the Court of Appeal in Extendicare. In my submission, what the Court of Appeal did there was to recognize that there are distinct roles, not contractual roles, but statutory responsibilities. And once that statutory responsibility has been exercised by an arbitration board, the only way in which that decision can be interfered with is by this court, not by the Labor Relations Board. It may have other remedial authority. It may well be that if there hadn't been an arbitration case, as McIntosh indicated, there would be authority. But there has been. And that means, both in terms of the scope of the legislation and as the court is assisted by the fact that this same issue has been dealt with on 2 occasions, the Labor Relations Board cannot do what it purports to do. Thank you.
Thanks, Mr. Rings. We won't, what the Divisional Court would normally do now is it would adjourn for 15 minutes, go out into a side room, and we would confer. I don't think we'll do that. We'll just come up and give our reaction to these fine arguments, and then talk a little bit about what you've heard this morning. These were fine arguments that you heard, and we were all sort of sitting together judging it. Now, it's hard for you because you probably haven't read the material carefully, thinking that you were going to have to give a decision. But I mean, last night I got this material, as I would and as we would in the ordinary course. Normally we're hearing 2 or 3 matters in a day. This matter would have been on with something else probably. Council would advise it's half a day. Last night I looked at the material, and I went and got copies of we didn't have case briefs given to us, so I went and looked at the Mordawanek case again and the Gendron case. And the issue here is one of an evolving or changing standard of review that's happened over the last 20 years. And Gendron and Mordawanek are really a product of a case called Lacadie, which reversed New Brunswick liquor effectively. New Brunswick liquor in about '79, the Supreme Court of Canada developed a patently unreasonable test, a very deferential test to administrative tribunals. And that was the culmination of 100 years of judicial review and judicial oversight of administrative agencies that was pretty heavy-handed. And I think a product of a lot of academic and other commentary that had been critical of the court. Then Lacadie, that honeymoon lasted for about 5 years. And then in Lacadie, the court started to tighten up. And it may well have tightened up because of what it saw as some pretty bizarre things happening in administrative tribunals, fashioning weird and wonderful remedies that the court worried about. And so it resurrected this jurisdictional test and trying to decide whether this is a provision that limits the jurisdiction of the tribunal. If so, the tribunal's got to be correct in deciding it. Or is this a provision the legislature intended the tribunal to apply with only a modicum of second guessing by a court? And you can see that this is a mug's game, this kind of a test. I mean, all of these provisions are jurisdictional in the sense it's a statutory tribunal. And all of them confer powers. And so Lacadie, using a listing, limiting approach to remedies, was a very regressive decision seen through the eyes of tribunals and those kind of interested in as much autonomy as possible by these expert boards. And more recently, Bibo, same judge, I think Betts, the late Mr. Justice Betts, sort of reacted, I think, to the criticism of Lacadie and developed a more deferential standard to determining jurisdiction by saying we'll use a pragmatic and functional test when asking whether this is a jurisdictional provision or not, and that's 89. And so these cases came in that Mr. Riggs is relying on are 86 cases, and so his challenge is overcoming the recent change in the approach to the standard of review. And so if I were deciding this, I look at it, not having conferred with my friends, but I would be saying to my colleagues, if I were allowed to go first, and if I'm the junior judge, I wouldn't be chairing this panel. I'd be sitting maybe in John's position. I would explain to my colleagues what I thought about the case, and I would say, look, this is in the area of remedies. We've already got a violation. if you're going to defer to tribunals, we ought to be deferring in the area of remedies. And this is a highly creative area. It's creative in the courts as well. Contracts don't say specific performance. Contracts don't set out the remedies. And so we should be gentle here in looking for legislatures setting out in detail what powers there are, and this is a remedial provision. So, and we ought to downplay Gendron and Mordawanek as a product of an earlier test that's been changed, and that we ought to say, applying a pragmatic and functional test, this is for the board to determine. Therefore, it's a patently unreasonable standard. And this case, therefore, you can't say that it's clearly irrational that one tribunal refuses to reinstate and the other reinstates. They are different jurisdictions, and it's no different than a wrongful dismissal that also is on the doorstep of the Human Rights Tribunal. And you might lose in court but win before the Human Rights Board, or vice versa. And so there is no inconsistency, there's no appeal here. Or if there is an appeal, it's not clearly, that's a view of this case, but it's just as useful a view to say that these are parallel jurisdictions, different jurisdictions, and that's what I would want to do. Now, I have two people who asked questions that were attracted to the way Mr. Riggs put it. And I could well end up in the minority in this situation. So we'd have to decide whether we were going to reserve and think about this. And this is a significant case. And unless we were unanimous, we might well reserve, and John or Leslie would say, well, I'd like to see, I'm from Missouri on this, but I'd like to see your draft. And we'd come out and announce it. But if the two of them were just bound and determined, they might say, no, we're against it, and we want to decide this right now before lunch. And we're going out, and you get gunned if you're in the dissent, because John's got his decision, and he's just going to dictate right off of Chris's factum. And Leslie's going to agree, and then they look to you for your dissent, and this is a good way to get a very mild dissent. I would have to say to them, look, we're not deciding it right now, then. If you're going to do that, I want to reserve, because I want to write something on this. And there might be a little tension on the panel as to exactly how we're going to play it. But that's my reaction. I'd be interested in the reaction of my colleagues. Leslie?
Well, I have new respect for what judges do. Just having had this brief experience, I find it really difficult to decide this case, and maybe it's because of being an advocate, you're used to sort of being able to argue both sides of something. I'd have a lot of difficulty deciding this case before lunch, and I think I'm probably persuaded that it's not a jurisdiction conferring or prescribing provision, so that it is within the jurisdiction of the board, although I'm not entirely persuaded of that yet. But if it is, even if it is a jurisdiction within the jurisdiction of the board, I'm not persuaded that it's not a patently unreasonable decision. I mean, I'd want to think some more about what Section 96.4 means, and also about how you read 96.4 together with 48, because they do appear in the same statute, and you have to know, you have to make some sense of the role of the arbitration board and the role of the OLRB. So I don't know if I'm going to be permitted to weasel out of this right now, but those are sort of the issues that occur to me anyway.
John?
Well, I would like to get it done by lunch.
I think I could have counted on that.
I was very interested, by the way, that the Labor Board retained Goldblatt in this case. I'm surprised at that after what Mitchell's been arguing, but in any event, probably was an earlier retainer.
Independent neutrality.
I think the analogy of the Human Rights Commission and wrongful dismissal doesn't quite fit here. The issue before the tribunal was whether there was an unfair representation, and I don't think they've dealt with that. They've gone on and dealt with the other issue, and that's whether there was a wrongful termination, which was the territory, the jurisdiction, if you will, of the Board of Arbitration. Now, I must say I was quite attracted to the argument that this labor board really can't effectively declare null and void the decision of a Board of Arbitration which was properly constituted to hear a case. And that the defect wasn't in that hearing. The defect was in the quality of representation. It's a different issue. However, I accept that there are different issues. But I don't think we can read the jurisdiction of the Labor Board, which is itself restricted to the matters before it. The matter before it was the question of unfair representation, not the justness of the discharge. That's what Section 114 of the Labor Relations Act says. And I don't think we can be we can't blur these jurisdictional lines, too quickly just because we're supposed to be functional and practical. I don't think there's much room in law for pragmatism.
I think this is good on the substance of judicial review. This shows you how subjective it can be, how this is fighting ground, and why there's some attraction coming to the court. On the presentations, I think you saw 3 marvelous presentations. And if you look at each one of them tactically, I mean, they had 15 minutes, and if you can't make your case in 15 minutes, you start to lose the court in any event. I mean, you really do. When you've got a big case, sometimes you simply can't do it in 15 or 30 minutes, but you are pressing everybody's staying power. And you've got to be able to say something pretty impressive in 15 minutes. And each of them did. Chris, right in your face, quick, with 2 decisions, one of our own. This is going to be, we can get through this. What he's doing is, you can get through this case quick. You know, you've got a backlog of cases, you've got other reserves. There's no problem with this. You've got a court, your own court's already decided it. You've got a Supreme Court of Canada case. Why do you want to bend yourself in a pretzel to handle this bizarre situation where they walk in, nobody says anything to the board, and then the board skirts around Gendron by reinstating directly? And just get through this. You got 2 cases. Don't think about this too hard. It's a very simple case. And we're talking about institutional integrity. Chris starts with the big picture, okay? You got some biases on the court. Not a court that is in love maybe with the trade union movement, but is concerned about the little person. So let's talk about the little person versus the big power interests and effective remedies. And by the way, this is a judicial remedy. This remedy, he starts, was created by the courts. This is your remedy. The legislature picked it up. This is the kind of stuff you've been doing. It's cutting edge. And you got a board that's simply perpetuating the implications of your remedy against this big union that is just screwing this little person, aided and abetted by industry and the captains of industry. So you get that picture, and then you, if you read his factum, it is loaded with, look, this is a remedy. We're in the remedy area. We already got violators. We got a recent Supreme Court of Canada case saying that in remedies, this is where you got to back out. You got to allow for innovation. And judges know that remedies, generally the documents on which you're giving remedies are always inchoate with respect to remedies. So, and there's nothing wrong with having two parallel tribunals. And when I asked him about Extendicare, he took Extendicare and made it his case. Said, look, there's a case where the court says no problem with conflicting decisions by parallel boards. They each have a different function. And then we get the labor board here to help us if there's a problem factually, or if council have kind of missed the big picture, and they hadn't, and Howard's factum was very good. There wasn't a lot he needed to say here, because Chris had done such a marvelous job, and so he comes in, he reinforces the standard of review, where this is. And the other thing too with Chris's argument, and Howard picked it up, you know, look at, there's this statute, half of the provisions are remedial. You're going to be second guessing and supervising all these remedies, have all these people on your doorstep, and both of them played that out. I don't know about my two colleagues, but I thought this was live. I mean, I felt like I had to make a decision, that I was being helped, and I was being manipulated by these three people in a very gentle but sophisticated way. This was a day at the Divisional Court, them arguing to you and us.
A good day at the Divisional Court.
A good day at the Div Court. Any questions?
So what, we're going to decide now or not?
One question here. Just, it seems straightforward to me, given the practical and functional approach. Why doesn't it more clearly address the issue of the only remedy was claimed against the union? So the board suddenly ordered the remedy against the employer. This seems fundamental to me. You could fashion the divisional court remedy either as practical and functional as far as jurisdiction, or legally unreasonable.
This was a very sophisticated case that's got a lot of history to it. A case I once decided as a vice chair of the OLRB is called Ward Shellington and Imperial Tobacco. It's the first case that joined the employer in a DFR violation. The real problem historically has been that when you get DFR violations in the context of an employer action, an employer fires, then the trade union does nothing about it. To get an effective remedy, you got to run an order against the employer. Not helpful to just nail the union. And the employer has benefited and been shielded by the actions of the trade union. And these, because it began as a judicial remedy, the courts in the U.S. worked at developing a remedy that they ran against the employer. And there were all sorts of metaphors used: shield, a beneficiary of the unlawful product. Then in Canada, we codified it all. And we didn't do a very good job. Quebec's a little better than our statute in adverting to this remedial complexity. So in this Ward Shellington case, I got the employer in by saying, look, there's a provision in the labor statute that says that everybody must abide by the collective agreement. So there is a substantive provision. Generally, it's not used as the basis to an unfair labor practice. And I said, that's because the board normally defers to arbitration. But that's an independent way to run the employer in here. Most people, that's too old a case, they just, but in the 70s, as a result of that case, it just became accepted that you join the employer. And the employer is on and is going to have to protect itself on the merits. And shouldn't just stand there. It's part of the play.
That was one of the things that troubled me about this case, though, that no one asked the board to reinstate the fellow. So that it may be that strategically, because that hadn't been a live issue before the board, the employer, didn't put its best foot forward because that hadn't been done.
To attack this case, the way this case might best have been attacked if you were the employer is on a natural justice basis. You come in and say, hey, that wasn't an issue. And suddenly you get a totally different court because there's no deference. And we're looking at this on whether you were set up or not, we didn't know, and we'd quash, send it back.
But that wasn't in the notice of application for judicial review in
No.
the town.
No, it wasn't.
No. I looked for it, I can tell you. Because I thought my friend Mr. Riggs might jump on that, so I was prepared to leap up.
I tried to get Mr. Gray to put that in the application, but he wouldn't go for that.
You could have put it in your factum anyway, as we heard from Mr. Murray or
Yeah, one
Mr.
thing,
Newbould.
just one thing in terms of this sort of advocacy issue in this, and this I think would be true of all of us, and that is, as Justice Adams mentioned, I mean, you do really have to go with your strengths when you're arguing these things. I mean, you only get so much time. The Divisional Court is not going to sit and listen to you endlessly for hours and hours as you go through 101 arguments, because I mean they've got other things to do. They've got a heavy docket. Certainly, from the employer's point of view, in this case, obviously one of the high trump cards is that there are two cases that at least to some extent, you know, are very supportive of the employer. And that really leads to the second point about, you know, what you're trying to get from the court. I think in many cases, and Justice Adams has raised this issue about making life easy for the court. I mean, I think in a number of occasions, you do have to recognize that with a busy docket, if you can provide the court with an easy way of ticking off ABC, application dismissed, you know, they'll be grateful for you for doing it. I would expect so. I think that's consistent with what he said. There are going to be some times, I think, where you're going to take a completely different tack. And that partly is going to depend upon the issue, partly it's going to depend on the disposition of the composition of the court, and partly it's going to even depend upon the hour of the day when you get heard. But there are some times when you are going to be saying to the court, look, I'm going to be arguing to you something which is quite different from what you've heard, and where I'm going to be asking you to make a decision quite different from the way you've done it before. In other words, I'm saying to you, I want you to look at this as an opportunity to make new law. Now, you're going to have to pick your spots on that, because, you know, if you're getting on at 3 o'clock on a Friday afternoon, setting new law is not what people are interested in at that time, right? And you know, you got to recognize that. That's the reality. But there are some times when you are asking them to, you know, you are appealing to an instinct of reserving, doing a lot of work, and coming out with something different. I don't think, from my point of view, in this case, that would be at all helpful. I have that terrible feeling that if this case were decided in the coffee break, I might win. I have a sneaking feeling if this stayed on reserve for a couple of months, my chances start to go down as the passage of time goes along. And for that reason, there's a real instinct in terms of, come on, I want to get a quick decision, because that's my best chance of winning.
One of the things, let me just add one other thing, Chris, is that one of the things that you do when you're in front of the court, and it was quite clear from the way in which we were questioned, is you've got to also read the court in terms of how familiar they are with the underlying law. For example, our facta, or factums as the case may be, are complete, Chris Paliare's and mine, complete with discussion of the Bevo case and the functional pragmatic test and all the various elements of it. And yet it's obvious that Justice Adams, within about 2 minutes of Chris Riggs' argument, raises functional pragmatic, clearly understands it, the court clearly is aware of it, and that you are not going to be inclined to sit there as you go through the steps in your factum outlining the various pieces. I mean, it's there in the factum, they know it, and you better move on to something else, or all you will do is tend to lose the court. They don't want people wandering, they don't want people telling them what they know. They really are looking for assistance, and I think if your factum is properly drafted and I think the word is crafted, if it's properly crafted, it will assist the court in identifying the areas that they need to hear more on, and it will frankly assist you in listening very carefully to the court in focusing on those areas. You can't read from your factum, and you really have to read the court, I think, as extensively or as precisely as you can. Hopefully, they're open. The worst thing is when they don't say anything and you have no idea whether they in fact know what you're talking about, which leads us to what we were discussing yesterday, when they come in and say, we've read the material and we're familiar with it, and then they say nothing, you really don't know how much they do know and how much they are familiar with. That, to me, is the biggest risk with your 15-minute presentation.
Yeah,